Alex here with part 25 of the My Docket series on Corazon real estate. We're going into my opposition to the motion for judgment on the pleadings. I can't remember my mindset. Um, Probably felt annoyed that I had to do all the research. But, that's a common sort of emotion, I guess, when it comes to this stuff is fear, annoyance, and then anger in some situations. I probably imagine that comes up more in the high conflict child custody stuff than in this stuff because this is just money. Um, I don't have any other thoughts, really. I think we should just go straight into what I have filed. Here we have my opposition to motion for judgment on the pleadings. Standard introductory paragraph indicating to the court that I am appearing in proper person, which means I don't have an attorney, and I am filing the opposition to the motion filed September 6th, 2013. Let's see. The lawsuit discusses violation of a statute, that the violations constitute oppression, implied malice, express malice, wrongful eviction, retaliatory eviction, failure to maintain. Conversion claims are merely secondary claims carried along with it. The oppression and the punitive damage award is, I guess I'm not saying it clearly, but I'm going to say it now, what I think the subject matter jurisdiction pivots on, because without the oppression and the punitive damages, this case can't be in district court. Not the appropriate vehicle. Why? Defendant might want to file a 12C motion. They would have to concede the claims of the case. Yeah, I mean, you know what though? Okay. It's true, I think, that it makes more sense if in some way the defendant is conceding the claims that they have in their answer admitted to. But on the other hand, even if that's true, I don't understand why the court just couldn't apply the motion to dismiss analysis anyway. So let's see here. Defendant will not succeed if there are allegations in the plaintiff's pleading that, if proved, would permit recovery. I mean, this is still, you can kind of horseshoe a defendant into using it in just treating it like a regular motion to dismiss for failure to state a claim. So it's a technical argument that I think doesn't matter. It's nice that I'm making it, but I don't think it matters. I don't see why the court wouldn't be able to try and just dismiss under the ordinary way that they dismiss anyway. Again, guys, you can watch the video Failure to State a Claim if you want to know more about what I'm talking about. And you can also compare it to judgment on the pleadings so that you can kind of get an idea as to why it's so awkward, in my opinion, that the defense filed this. Okay, so this portion here that points out to the court its error probably is something that nowadays I wouldn't put in, because it's kind of like rubbing salt into the wound. It is true that I won that appeal. And I'm trying to speculate that so I'm trying to say that Charles Chinichi already tried to dismiss this for failure to state a claim, and if the Supreme Court would have wanted to dismiss on that basis, they could have. Would have wanted to affirm on that basis, they could have. But I don't think I'm right. In hindsight, I can see why I thought this would be the case, but knowing what I know now about how they do not like non-attorneys representing business entities, I actually do think that they didn't bother to really go into any of the other analysis. As soon as they saw a non-attorney represented the corporation, they reversed. And so what I'm trying to say here, I don't think is true. It may be speculative, but it should be taken into consideration that if the claims were so beyond the realm of merit, the Supreme Court would have affirmed on that basis. I get why I'm saying this. I get why I think this, but I don't think it's true. So, yeah, they didn't affirm it on the other basis, but they didn't talk about it at all. So it doesn't control this court in any way. And I think I talk about that a little bit in the video Law of the Case. Supreme Court's consistently found error when the judge invented its own standard of review on a motion to dismiss, which is true. Court's dismissal of previously filed motion to dismiss was predicated on a failure to provide evidence. So, okay, but this isn't what's going on now. So I'm relying a lot on the court's mistakes in the past, but that's not going to control the outcome of this motion. The motion incorporates matters outside the pleadings. They attach documentary evidence to their motion to dismiss. Yeah, but I think they only attached court documents, which is probably okay. Pleadings allowed in civil actions. Oh, okay. Yeah, I mean, I get what I'm saying. You can only rely on the contents of the complaint, answer, and reply. That's true. This is a good case that I cited. But I don't think that they attached evidence to that motion. I think they just attached a couple of filings. And if they were filed, then I don't see why the court wouldn't be able to take judicial notice of them if they're actual court documents that were filed and file stamped. But I mean, at the same time, they would have to be in some way connected to the allegations. This is tricky. I feel like what they're doing isn't that improper. I do feel like it's not strong. It's not a strong approach when you're trying to bring things into the motion to dismiss analysis that aren't part of the pleadings, but maybe it's allowed in this particular situation. I haven't done the research on it. If you want to know more about why you really can't start bringing up evidence at the motion to dismiss phase, watch my video on the topic, failure to state a claim. There's a reason why, or early case termination, that's a better video. Later on, you can try and do that in mid-case termination, which is another video, and I talk about the summary judgment mechanism in that video. There's a lot of stuff that goes into these different phases. So we're talking about summary judgment now. Why? I guess because they brought up evidence. So I'm kind of transforming the analysis into summary judgment. I don't know if it was okay to do this. I've heard that it's possible for a court to take a motion to dismiss and treat it like a summary judgment motion. I've heard this is possible. I don't know if it's a law or a case that allows it. So I guess it's not totally out there that I'm trying to deal with this problem. But it is good that I at least touched on it and that I brought up the case that states that without discovery having been conducted, summary judgment is not appropriate. And they talk about this here. Air conditioner and stove repairs. I feel like I should be, okay, no, I am. This is good. So I'm bringing up the allegations. I'm talking about the air conditioner and stove repairs, and I'm pointing out the allegations, which supports that I have alleged what I needed to allege. Interestingly, their attempt to rely on Justice of the Peace James Mancuso's ruling is something that I'm trying to block with this case. Where is it? Yeah. So the Supreme Court of Nevada created an exception to claim preclusion when it comes to summary eviction proceedings. I would probably read this again before I ever tried to do this because I don't think it's 100% barring claim preclusion, but I do think that there is some logic in there that explains why they created the exception. And what I'm trying to do is I'm trying to argue that they cannot rely on this judge's ruling to preclude me from bringing this new case in front of a different judge. Normally, you can do that. And if you watch the video claim preclusion, you can find out why. But I'm arguing that there's an exception here because the Supreme Court of Nevada specifically published a case saying so. And the logic behind why they did this makes a ton of sense. It's because of the limits of the summary eviction judge's power. In summary eviction court, there's only two things that the judge can do: grant a summary eviction or deny it based on not believing the tenant, but on arguing that the tenant raised a valid legal defense. So that's not really saying the tenant was right. That's just saying they brought up a legal defense. Whether it's right or wrong hasn't been decided yet. And so that's what's complicated about this type of situation and why the Supreme Court created an exception. Okay, so that's done. Statutory rights, punitive damages. Okay, I've already talked about this before at length in the series, but in a nutshell, I think, let's see here. Hold on a second. I'm trying to find a good spot to pause this page. Yeah, so if you just order the landlord to pay the tenant back the money that they were deprived of, it's not actually going to stop them from doing what they're doing. And I've talked about this before in this series, so I'm not going to rehash it right now. But that's the point of punitive damages, is to make it very unprofitable for them to coerce their tenants out of their statutory rights. And by taking away their profit, then they'll stop doing it. If you just order them to pay back one of the people that they've ripped off, they've still successfully ripped off all of the other tenants. There's no basis for them to stop doing what they're doing. Punitive damages is supposed to mathematically deal with that problem. You guys can learn more about it in the video, Punitive Damages. So yeah, they're basically saying that you have all these laws and it doesn't matter because you're going to be so scared of being evicted that you're just going to let us step all over your rights. And that's where oppression comes into play. And this case here, Hansen v. Harris, I think is a really good analogy. The only thing that's frustrating is this is in the context of an employer and workers' compensation. It would be really nice if a case like this published on landlord-tenant stuff, because I do think that this is analogous, and that if a case like this doesn't publish, then tenants are just going to keep ripping people off. There has to be some publication from the Supreme Court that says there is a difference between telling somebody they have to pay money after they've moved out and telling somebody that if they don't pay money, you're going to evict them. There's a big, big difference there because of the arm twist, because of the coercive element of the threat of eviction, especially if they have a family and kids. Relationship between punitive damages. Okay, so I'm defining the differences. If you can learn more about this by watching the video Punitive Damages, and then I have another video called Compensatory Damages, and I'm just explaining the difference between the two and how they work. And this is it explains there's no relationship between the punitive and compensatory damages, which is true. Well, sort of. Not, okay, there's no relationship between them just automatically, just because. But some legislatures have enacted statutes that, because of the statute, they create the relationship. So just automatically, it's not there. But some states may have enacted statutes that argue otherwise, or not argue that change the rules. Let's say that. And in Nevada, we do have that statute now. It's not that old. It's pretty new. When it comes to law, new is, I don't know what you want to call new. 10 years? I don't know. I'm just going to move on so we don't get stuck. So oppression, they talk about oppression in the Harris case, and then they also talk about it a little bit here in Ainsworth in the context of making unconscionable contracts. Basically, in Ainsworth, the losing side that got hit with punitive damages said it wasn't fair because they were just abiding by their contract. And they said, okay, well, maybe our contract was unconscionable, but we didn't know. We just thought it was enforceable. And the Supreme Court said that we have a problem with this logic, because if we allow you to get out of punitive damages because you thought you were enforcing a valid contract, all we're going to do is create a situation where people or companies, corporations, will purposefully create contracts that are unconscionable just so that they can get out of punitive damages. And let's see if okay, so I know that they talk about that. Let me find it. Okay, guys, hang in there. I'm going to bring that up because I'm pretty sure that that's something under Ainsworth. Okay, yeah. Let's keep going. I know it's in here. Just hang in there. Bear with me. Contract between the parties is unavailing. So we're going to talk about contract unconscionability. I have a video on this topic. It's pretty complicated. Watch my video on contract unconscionability, and then you can also watch my video on adhesion contracts. I'm trying to say that even if there is a contractual provision that allows a landlord to do what it's doing, the provision is in violation of public policy. And there's actually a statute in Nevada under the landlord-tenant stuff that specifically says that. Here it is, 118A sub 220. This is a law that states, quote, that if a tenant agrees to waive or forego rights or remedies afforded by this chapter, it's void as contrary to public policy. They didn't even have to do this. The legislature didn't have to enact a statute to make it so. It would have still been this way. But by them creating this law, they really underlined and highlighted the point that if you make a tenant sign something that's that's contrary to these laws, then it's void. Or if make the tenant waive their rights or forego their rights, no, it's void. And then I'm bringing up the contract itself, which I think I was right on. Yeah. And then I can bring up ambiguities. Contractual ambiguities I can use against the drafter. This is true. This is a pretty common legal maxim. Here it is, guys. Ainsworth versus Combined Insurance Company. The insurer may not rely on its own ambiguous contract as the sole basis for denial of punitive damages. To allow such conduct would only encourage ambiguous contracts. So they're going to conclude that the jury award for punitive damages is supported by substantial evidence. Wow, and that's not even talking about unconscionability. That's just talking about ambiguous contracts. So that's like even more, I think, plausible as a basis to say, sorry, we didn't mean to do this. I mean, because you're not even saying that it's unenforceable. You're just saying it's ambiguous. So that's an excellent ruling. Subject matter, jurisdiction, and the legal certainty test. Okay, I really wanted to talk about this. So I'm glad that this came up. This is a big part of the case, at least for it being in district court. They're saying that without the punitive damage award, there is no jurisdiction here, and that's true. The punitive damage award is the only way to keep jurisdiction in the district court in this case because the damages are way too low. So here's the question. Who proves that? Who is supposed to prove that there is a potential to get punitive damages? Is it the plaintiff side or is it the defendant side? And I wondered about that. And then I learned about something called the legal certainty test. And that is mentioned in a case. I'm going to scroll. Here we go. Okay, so when you're dealing with jurisdictional minimums to get into a court, so like the dollar amount has to be a certain amount. You know what? I'm going to read this one verbatim because I think it's really at the central, it's the crux of the jurisdiction argument in this case. Although we have not previously addressed what standards should guide the district court in determining whether the claim damages meet the jurisdictional requirement, federal courts apply a, quote, legal certainty, unquote, test to determine whether a complaint satisfies the amount in controversy requirement of diversity jurisdiction under the law. I don't know what they mean by diversity jurisdiction, so right away that's a yellow flag in my brain going off. You should check this, Alex, but this case is closed now, so I'm not going to do that. You guys can check it if you want. A court should be cautious about dismissing a complaint for failing to meet the jurisdictional requirement. Under the legal certainty test, it should be emphasized the plaintiff must establish merely that it does not appear to a legal certainty that the claim is below the jurisdictional minimum. Thus, under the standard, courts must be very confident that a party cannot recover the jurisdictional amount before dismissing the case for want of jurisdiction. So that's really this is a strong case, even though this is I think, what is this in? Oh, no, yeah, okay, I was going to say this is a federal case, but look, it was cited in the Nevada Reporter, so the Supreme Court of Nevada actually cited this federal case, so they adopted its analysis or its logic. And yeah, I mean, all I have to do is show that there is no legal certainty that the amount will be below. And that's by raising the punitive damages. By raising punitive damages and claiming that, I think that I have done more than enough. They, on the other side, the defense can go ahead and try and bring up evidence. They're going to have to talk about their net worth and their accounting, which they're not going to want to talk about because punitive damages is going to be connected to their net worth. But I mean, all I had to do was show, based on my claims, that there is no legal certainty that it's going to be underneath. It's murky. It's quite murky. It's going to depend on the facts, on the punitive damages, on the award. There's a potential. So yeah, I'm glad that got brought up. Failure to maintain the toilet. I'm probably going to just be citing an allegation here because that's all I have to do at this point. Statutory construction principles here. Okay, so I'm talking a little bit about best efforts. Oh yeah, this is a good point. This is an excellent point. Whether or not the defendant's conduct constitutes best efforts is per se a genuine issue of material fact. It absolutely is. That's like the word reasonable. Okay, if something is reasonable or not, that's murky. That's complete. That's opinion. Whoever's, in control of the case, whether it's the judge or the jury, is going to decide that when they consider all the evidence. There's no way to really deal with that at this early, stage in the process. Retaliatory eviction, wrongful eviction. Yeah, so they said that since I was not evicted from the unit, that means that I can't bring wrongful eviction or retaliatory eviction. And this is what I was talking about in the last video, that there was some kind of case law, legal advice that if you are coerced, that's good enough. You don't actually have to wait until you really are evicted. I wonder if I have, all I'm saying here is that they failed to cite points and authorities. That's what Cunningham v. State is. That's what DCR 13.2 is. It would be nice if there was a case on this. So under the retaliatory eviction statute, all they have to do is threaten to bring an action for possession. So that's good. They don't actually, and they did bring one. So it doesn't talk about here whether they accomplished it or not. It says they bring it or they threaten to bring it. Okay, so it seems like that fits within NRS 118A. This is the retaliatory eviction statute. I am curious, though, about wrongful eviction, and it doesn't look like I cited any points and authorities on that. So that would have been nice to do some more research on that, but I imagine it was just something that slipped my mind. I didn't understand at the time. Conversion of the security deposit. So I already think I'm wrong about this. Let's see what I'm saying, though. I'm bringing up the definition of conversion, and that's fine, but that's still not this. I'm still wrong. This would have been better done under a breach of contract or under that specific statute in the landlord-tenant scheme. The attorney was right here. So dismissing the claim on a technicality would be manifest error. It's not true. Inconsistent with this case, not true. It would not be. It would be the correct ruling by the court to dismiss this claim. Hearing. If the court intends to raise arguments on the defendant's behalf, I'm requesting a hearing before they dismiss any claims. Okay, yeah, and then here's my request to amend. So this would allow me to cure the issue with the conversion. I could change the claim out from conversion to breach of contract, or I would use that statute. Okay. Conclusion. This is basically already what I've been talking about the whole time about how landlord-tenant stuff is going on. This back then it was a problem, and now it's even worse. So, declaration. Rule 5 certificate of service indicating I mailed this to the attorney. We got some exhibits here. So I'm doing the same thing. I shouldn't be bringing stuff up that's outside the boundaries of the allegations either. So this is not, oh no, that's not true because I did discuss the summary judgment stuff. So I guess part of this I deal with the fact that they're bringing an early case termination mechanism against me, but the other part is me addressing what if the court wants to deal with this as a summary judgment motion. So then it does make sense that I'm talking about this other stuff too. If the court did want to kind of take that approach, then exhibits 1, 2, 3, 4, and 5 might actually become relevant because they could help me create a genuine issue of material fact. I'm not sure if any of you guys, if any of these have already been filed, I'm going to skip over them. So this is like for sure. This would have been filed when Charles Chinichi filed his motion to dismiss. So I know this has been brought up. I'm not going to go over this a second time. Same thing. This is just a docket. Same thing. Okay. Guys, I've gone over all this stuff already. As my previous videos, you can always go down into the description below, click on the link, download it for yourself, take a look. And if you see something in there that makes you think I missed something, just mention it down in the comments and I'll try to address it. This looks like sorry, I'm talking too fast. This is an accounting, and I'm not sure that this actually was brought up before, but it's not a legal document. So you guys can take a look at the accounting if you'd like to. It's just the back and forth, the payments of rent, the expenses, the billings, all that stuff. Not a legal document. You guys should be able to understand it on your own. That's all I'm going to say about it. I'm just going to scroll all the way through it just in case something jumps out at me. No, nothing jumped out. Going into the aftermath, I filed one document, but it was a free filing, so I incurred $0 in costs. The Corazon Real Estate did not file anything, so they incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. They would have had to review the opposition. Most of the time is going to go into the reply, but I will at least say, I think, to go through this from top to bottom, I feel like an hour. No, because they're going to have to call their client and possibly bring up some of the things. An hour sounds reasonable. So 1 hour at the rate of $250 an hour, that's going to come to $250 in attorney fees for Corazon Real Estate. As my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.